Okay, so let's dive into evidence. If you're prepping for the bar exam and the MBE in particular, and you're feeling a little overwhelmed by evidence, I feel you. It can be a lot. But that's exactly why we're here today. We're going to do a deep dive into the world of MBE evidence. We're going to try to make it feel a little less scary and a little bit more manageable. What we're going to do is we've got some lecture transcripts and multiple choice questions we're going to use as our guide, and we're going to pull out all the really key takeaways, the things that you absolutely need to know to do well on MBE evidence. And to help us do that, we've got our evidence expert back. Jackson Mummy from Celebration Bar Review. Jackson, thanks for being here.
Happy to be here. Always excited to talk about evidence.
So let's jump in. When you're tackling MBE evidence, how do you even start? Where do you begin with all this stuff? Your first lecture transcript kind of lays out a plan. You start with presentation of evidence and you work towards hearsay. Is that how you recommend students approach it?
Yeah, I think that's a good way to go about it because it follows the way that a trial actually goes, right? You start with like, okay, how is evidence presented? Who can testify? And then you kind of move on to, well, what evidence is even relevant? How do we authenticate things? And then finally you get to, okay, what about all these out of court statements? So that flow kind of naturally builds upon itself.
Right. You're starting with the foundations and then moving to more like, I guess you could say, nuanced areas. Yeah, that makes sense. Build the groundwork first and then add those layers. And just to be super clear, for the MVE, we're talking about the Federal Rules of Evidence, right? That's the law we have to know inside and out.
Yeah, the MVE is pretty much all about the FRE. So while your state evidence rules might be important for the state portion of the bar exam, for the MVE, it's really all about the federal rules.
Got it. Federal rules. That's our cheat sheet. So let's dive into witness testimony. One of the first things you talk about in your lecture is the oath or affirmation. What's the key takeaway here for MBE prep? When it comes to the oath, what do students really need to know?
You know, it's interesting because under the FRE, it doesn't really matter why a witness feels compelled to tell the truth. So, in the example in my lectures, I use this kind of out there scenario where a witness believes they'll be punished by a higher power if they lie. But the reason doesn't matter. What matters is that they've made this promise to tell the truth, whether it's through an oath or an affirmation. The court isn't going to get into, their religious beliefs or personal superstitions or anything like that. So on the MBE, if you get a question that tries to throw you off with some weird reason for a witness to tell the truth, just remember it's not about the why. It's about the promise itself.
Okay? So focus on the promise, not the reason behind it. Now let's talk about expert witnesses. A lot of students probably think, okay, to be an expert, you need some fancy degree, like a PhD or something. But your examples from your lectures, they kind of paint a different picture. You talk about like a neighborhood mechanic, and then of course there's the classic my cousin Vinny example. What should MBE takers really understand about who can be an expert?
That's a great point. You know, being an expert isn't about having a certain degree or title. It's about having knowledge that goes beyond what the average person knows. So that could come from formal education, but it could also come from, years of experience, like that neighborhood mechanic who's worked on cars his whole life. Or it could even come from something like a hobby, like in My Cousin Vinny, where Marissa Tomei's character becomes an expert on cars through her family's history with them. So just ask yourself, does this person have knowledge that would help the jury understand something or determine a fact in the case? It doesn't really matter how they got that knowledge.
So it's about know-how, not necessarily a diploma. Okay, and once you've got your expert, what about their opinion testimony? You touched on this historical ultimate fact rule in your lecture and how it relates to insanity defenses and the whole John Hinckley case. What's the bottom line here for the MBE when it comes to expert opinions?
Right. So traditionally, courts were really hesitant to let experts basically tell the jury what to decide, like to give an opinion on the ultimate legal question in a case. But over time, that's changed a bit. The federal rules generally allow experts to offer opinions on ultimate issues. Now, there's this one important exception for insanity defenses that comes from the Hinckley case. So, because of that, an expert can't just tell the jury, hey, this defendant was legally insane. But outside of that narrow exception, experts can usually give opinions that touch on those key factual questions.
Okay, so remember that insanity exception for criminal cases. Otherwise, expert opinions are usually fair game. Now, let's talk about questioning witnesses. Leading questions. They often seem like a big no no, right? But in your lecture, you mentioned there are exceptions, like with hostile witnesses. And when you're covering preliminary matters, what's the thinking behind allowing leading questions in those situations?
Yeah, so the general rule is you can't use leading questions on direct examination because you don't want the lawyer to be like putting words in the witness's mouth. Right. But with a hostile witness, someone who's being uncooperative or evasive, leading questions are allowed because it's like, well, this witness clearly isn't going to just blindly agree with whatever the lawyer suggests. And then for preliminary matters, just basic stuff like the date and time or where something happened, those leading questions help move things along. And they're not really likely to influence the witness's testimony in any meaningful way.
Yeah, it makes sense when you think about it that way. Practicality over strict formality. Now, what happens when a witness forgets something on the stand? That's where refreshing recollection comes in. And I have to say, your smelly sock example from your lecture is one I'll never forget. What's the most important thing for MBE takers to remember about refreshing a witness's memory?
Yeah. Well, the main thing to remember is that you can use almost anything to refresh a witness's memory. It could be a document, a photo, a song, even a smelly sock. The point is to jog their memory, but the crucial part for the MBE is that once their memory is refreshed, they have to testify from their recollection. The item itself isn't usually admitted into evidence. So, the smelly sock wouldn't be given to the jury or anything like that.
Oh, that's interesting. So it's like the memory trigger is just a tool, it doesn't have evidence itself. Ooh. Let's switch gears a bit and talk about judicial notice. You distinguished in your lecture between legislative facts and adjudicative facts. Which one should students be focusing on for the MBE?
Yeah, so judicial notice of legislative facts, that's more about like general background information that courts use to understand the law. It's not something you'll see tested very often on the MBE. Adjudicative facts, on the other hand, those are the specific facts of the case that can be easily verified or that are like common knowledge within the jurisdiction. Those are the facts that are more likely to come up in MBE questions.
So, adjudicative facts are those case specific things that are easy to prove or just widely known? Yeah, got it. Moving on to cross examination. This is a big one. What are some of the improper cross examination tactics that should raise red flags for students on an MBE question?
One of the biggest ones is asking confusing or misleading questions, like throwing multiple questions at the witness at once or rephrasing the same question over and over again in a way that's like designed to trip them up or mischaracterizing their prior testimony. Those are all no-nos. The goal of cross-examination is to test the witness's credibility and memory, not to bully or confuse them.
Okay, so one question at a time, no badgering, and be fair to the witness. Solid advice for cross examination. Now, let's get into impeachment. This is a huge area of evidence. You break it down into different categories, starting with prior inconsistent statements. What's the big picture principle here for the MBE student?
So the basic idea is if you can show that a witness has said different things at different times, that can damage their credibility, right? So you can use prior inconsistent statements to try to impeach them. Now, if it's an oral statement, you generally don't have to lay a super formal foundation before you bring it up. You just need to have a good faith belief that the statement was actually made. But if the prior statement is in writing, you got to show it to opposing counsel before you question the witness about it.
Got it. So, oral statements need good faith, and written statements need to be shown to the other side. Makes sense. Next up, impeachment based on bias, prejudice, interest, or corruption. How can students spot this on the MBE?
Basically, anytime you see a fact pattern where a witness might have a reason to slant their testimony in a certain direction, that's biased. Maybe they're getting paid by one of the parties, or they have a personal relationship with someone involved in the case. The thing to remember for the MBE is that you need to have a good faith belief that this bias actually exists before you can start asking the witness about it. And if they admit the bias, then generally can't bring in any other evidence to prove it. The jury will just have to weigh that admission when they decide how much weight to give the witness's testimony.
So if the bias is admitted, no need for extra proof. Now, let's talk about impeachment based on poor character for veracity. In other words, attacking a witness's tendency to lie. You outline several ways to do this, including using crimes of dishonesty. What's the MBE takeaway here?
Yeah, so crimes that involve dishonesty or false statements, and they are always admissible to impeach a witness because they directly relate to their truthfulness. So if a witness has been convicted of perjury or fraud, that can be used to attack their credibility on the stand.
Okay, so perjury and prior convictions, those are always fair game for impeachment. Got it. What about felonies in general? Is it always okay to use those to impeach a witness?
Not always. With felonies, the court has to balance things out a bit. They have to weigh how much the felony tells us about the witness's truthfulness, that's called probative value, against how unfairly it might prejudice the jury, that's the prejudicial effect. And when it comes to a criminal defendant who's being impeached with a prior felony conviction, the prosecution has to show that the probative value substantially outweighs the prejudicial effect. So the bar is higher for them. Another thing to keep in mind is that more recent felonies are generally considered more probative than old ones. And even if a felony conviction is being appealed, it can still be used for impeachment. But the witness is allowed to mention the appeal to the jury.
Right, so felonies involve a balancing act, and criminal defendants get some extra protection. You also talked about prior bad acts, which are basically specific instances of conduct that relate to truthfulness. How do those work on cross-examination in MBE land?
So you can ask a witness about specific instances of their conduct on cross-examination, but only if those acts are relevant to their character for truthfulness. Like lying or cheating or that sort of thing. But here's the catch, and this is important for the MBE.
I'm listening.
You can't bring in any other evidence to prove that these bad acts actually happened. You're stuck with whatever the witness says on the stand. I always use the example of a witness who claims to have a bachelor's degree and the diploma is in crayon. You can ask them about it on cross-examination, but you can't bring in the fake diploma made with crayons to prove they're lying.
Okay, so ask away, but no outside proof allowed. Got it. And then the last way you mentioned to attack a witness's character for veracity is to use opinion or reputation evidence. How might this come up on the MBE?
So you might see a question where one witness is asked about their opinion of another witness's truthfulness. Like, do you think this person is honest? And the key there is that the questioning witness needs to have personal knowledge about the other witness's character. It can't just be like a random guess. Or you might see a question where a witness is asked about someone's reputation for truthfulness in the community, and that focuses more on what people generally think about the person, not just on the questioning witness's own opinion.
So opinion is more personal, and reputation is more about the community's view. Got it. Okay, so let's say a witness has been successfully impeached. Is there anything that can be done to try to repair the damage? You talk about rehabilitation, and I really liked your example about the $5,000 check. What's the key concept here for the MBE?
Yeah, so if a witness has been attacked on cross-examination, the side that called them can try to rehabilitate their credibility by introducing evidence that explains or contradicts the impeachment. So, for example, if the cross-examiner brought up that $5,000 check to suggest that the witness was biased or corrupt, the other side might try to show that the money was actually for a legitimate business deal, and that would help to restore the witness's believability in the eyes of the jury.
So rehabilitation is all about providing context or counterarguments to the impeachment. Okay, let's move on to relevance. It seems pretty basic, right? Relevant evidence is good. Irrelevant evidence is bad. But how do we define relevance in the context of MBE evidence?
You're right, it does seem basic, but it's actually a really important concept for the MBE. Relevant evidence is anything that has any tendency to make a fact of consequence more or less probable than it would be without the evidence. So it's pretty low bar. As long as the evidence has some connection to a fact that matters in the case, it's probably going to be considered relevant.
So, any connection to a key fact, no matter how small, is enough to make evidence relevant. That's good to remember.
But I want to stop us here for a moment. There's a terrible habit that bar takers have with respect to relevance on the bar exam.
Oh, what's that?
They feel compelled to discuss relevance before each piece of evidence is evaluated. That's not necessary, and in fact, is often a wrong answer on the MBE,
So, when do you talk about relevance?
only when it's in dispute.
And for more on this topic, our listeners should check your evidence lecture. Now, let's talk about character evidence in general. You can't use someone's character to show that they acted in a way that's consistent with that character, right?
That's exactly right. We call this the rule against propensity evidence. So you can't argue that just because someone has a reputation for being dishonest, they must have committed the crime of fraud in this particular instance. It's not fair to assume that people will always act in accordance with their past behavior.
But of course, there are exceptions. Yeah, you taught us a handy mnemonic, MIAC, to remember some of them. Can you remind us what MIAC stands for and how it applies to MBE evidence?
Absolutely. MIAC stands for motive, identity, mistake, absence of intent, and common plan or scheme. So if character evidence is being offered for one of these specific purposes, it might be admissible even though it wouldn't be allowed to prove propensity. So for example, if the prosecution is trying to show that the defendant had a motive to commit the crime, they might be allowed to introduce evidence of the defendant's prior bad acts, even if those acts are similar to the crime charged.
Okay, so MIAC gives us those specific non propensity uses for character evidence. What about habit and routine practice? How does that differ from character evidence on the MBE?
So habit is a much more specific and consistent response to a particular situation. It's more like an automatic reflex than a general character trait. So, for example, if you always lock your front door as soon as you walk inside, that could be considered a habit. And evidence of a habit can be used on the MBE to show that someone probably acted in accordance with that habit on a specific occasion. Routine practice is similar, but it applies to organizations like businesses. So, if a company has a standard procedure for handling customer complaints, evidence of that routine practice could be used to show that they probably followed that procedure in a particular case.
So, habit is specific, and routine practice applies to organizations. Got it. Now, what about subsequent remedial measures? Let's say a company fixes a dangerous condition after someone gets hurt. Can that be used as evidence that they were negligent in the first place?
Generally speaking, no. The federal rules don't allow subsequent remedial measures to be used to prove negligence or other culpable conduct. The idea is that we want to encourage people and companies to fix dangerous situations without worrying that those fixes will be used against them in court. But there are a few exceptions. For example, if the defendant denies owning or controlling the property where the accident occurred, evidence of subsequent remedial measures might be admissible to prove ownership or control. Or, if the feasibility of a safer design is disputed, evidence of a subsequent design change might be admissible to show that it was possible to make the product or property safer.
So, the rule encourages safety improvements without fear of legal consequences. Makes sense. What about compromise offers and negotiations and offers to pay medical expenses? Are those admissible in MBE evidence?
No, those are generally inadmissible to prove liability. The policy behind these rules is to encourage settlements and to promote good Samaritanism. So if you offer to pay someone's medical bills after you hit them with your car, that offer can't be used as evidence that you were at fault. But there's a little caveat here. Factual statements made during settlement negotiations might be admissible for other purposes. So be careful about what you say during those discussions.
So settlements are encouraged and acts of kindness are protected. Good to know. Let's shift gears again and talk about authentication. When you're dealing with writings, recordings, or photographs, what's the basic requirement for getting them admitted into evidence on the MBE?
You have to authenticate them. Basically, you have to prove that they are what you claim they are. That the document is actually signed by the person you say signed it, or that the recording is a true and accurate representation of the conversation that took place. It's all about laying a foundation for the evidence before the jury can consider it.
So prove it's the real deal before it goes to the jury. Got it. What are some of the common ways to authenticate evidence directly on the MBE?
There are a bunch of ways to do it. You could have someone testify that they saw the document being signed or the recording being made, or someone who's familiar with the purported author's handwriting could testify that they believe the signature is genuine. Or if it's a business record, the custodian of those records could testify about the company's procedures for creating and maintaining those records.
Okay, so eyewitness testimony, handwriting comparison, or testimony from a record keeper. All good options for authenticity. Now let's talk about the best evidence rule. This one's a little tricky. When does it come into play on the MBE?
Yeah, the best evidence rule can be confusing. The key thing to remember is that it only applies when you're trying to prove the contents of a writing, recording, or photograph. So if the question is about proving what a contract says or what's in an email, that's when the best evidence rule kicks in.
Okay, so content is key, and in those situations, you usually need to produce the original document, right?
That's the general rule, but there are a lot of exceptions, and duplicates are usually considered just as good as the original, unless there's a reason to doubt their accuracy.
So photocopies and scans, those are usually fine. What are some of the common exceptions to the best evidence rule that MBE takers should be aware of?
So if the original document has been lost or destroyed, and it wasn't the fault of the party who's trying to introduce the evidence, then a duplicate might be admissible. Or if the original is in the possession of the opposing party and they refuse to produce it, that's another exception. And then there's this idea of collateral matters. If the contents of the document aren't really central to the case, then a duplicate might be allowed. It all comes down to practicality and fair.
Got it. Now the big one. Hearsay. This is probably the most feared topic in all of evidence law. You defined it in your lecture as an out-of-court statement offered in court to prove the truth of the matter asserted. That seems pretty straightforward, but there are so many exceptions and nuances. What are some examples of things that look like hearsay, but actually aren't considered hearsay on the MBE?
Yeah, hearsay is definitely a tricky one, but there are a few categories of statements that are specifically excluded from the definition. So, for example, if a statement is offered to show its effect on the listener rather than to prove the truth of what was said, it's not hearsay. So imagine a witness testifies that they heard someone yell fire in a crowded theater. If that statement is being offered to show that the witness was startled and ran out of the theater, it's not hearsay. But if it's being offered to prove that there was actually a fire in the theater, then it would be hearsay. Another example is verbal acts or legally operative facts. So words that have independent legal significance, like the words, "I accept your offer" in a contract. Those aren't hearsay because they're creating a legal obligation. And then finally, statements that are offered to show the speaker's state of mind rather than to prove the truth of what was said are also not hearsay. So if a witness testifies that the defendant said, "I'm so angry I could kill someone," that statement wouldn't be hearsay if it's offered to show that the defendant was angry. But if it's offered to prove that the defendant actually intended to kill someone, then it would be hearsay.
Okay, so effect on the listener, legally significant words, and the speaker's state of mind, those are all non-hearsay. Now, you also talked about a category of statements that are not hearsay by rule, specifically opposing party admissions. What's the deal with those?
So the FRE has this special rule for statements made by a party to a lawsuit. Basically, anything a party says can be used against them in court, even if it wouldn't normally be admissible as hearsay. And this rule applies even if the statement wasn't against the party's interest when they made it, or if they didn't have personal knowledge of the fact they were talking about. It can get a little tricky, though, because there are several different types of opposing party admissions. You've got statements made by the party themselves, obviously, but you've also got adoptive admissions, which are situations where a party remains silent when a reasonable person would have denied the accusation. And you've got statements made by people who are authorized to speak on behalf of the party or by agents and employees who are acting within the scope of their employment. And finally, you've got statements made by co-conspirators during and in furtherance of the conspiracy. The MBE loves to test the nuances of these different types of opposing party admissions, so be sure to study them carefully.
Ow. So basically, anything the other side says can potentially be used against them. No wonder they call it the admission rule. Okay, let's move on to the actual hearsay exceptions. We'll start with the ones that apply when the declarant is unavailable. What makes someone unavailable for hearsay purposes?
On the MBE, there are a few different situations where a declarant is considered unavailable. They could be exempt from testifying because of a privilege like the attorney-client privilege or the spousal privilege. They could refuse to testify even though the court orders them to. They could genuinely not remember the events in question. They could be dead or too ill to testify, or they could be beyond the reach of the court's subpoena power, like if they've moved to a different country. Make sure you know all of those possibilities for the MBE.
Okay, so privilege, refusal, memory problems, health, death, and being out of reach. Those are all reasons why a declarant might be unavailable. And when that happens, we turn to the hearsay exceptions that apply in those situations. What are the most important ones for the MBE?
The big three are former testimony, dying declarations, and statements against interest. Former testimony is testimony that was given at a prior trial, hearing, or deposition where the party against whom the testimony is now being offered had the opportunity and a similar motive to cross-examine the witness. Dying declarations are statements made by someone who believed they were about to die about the cause or circumstances of their death. They're admissible in homicide cases and in civil cases, but only if the declarant actually died. And statements against interest are statements that are so contrary to the declarant's own financial or legal interests that a reasonable person wouldn't have made them unless they were true. There's an extra requirement for statements against penal interests that are offered to exculpate a criminal defendant. In that situation, there has to be corroborating evidence to support the statement.
So, former testimony, dying declarations, and statements against interest. Got it. Now, let's talk about the hearsay exceptions that apply regardless of whether the declarant is available. You called these the spontaneous exceptions in your lecture. What are the ones that MBE takers should really know?
Yeah. So these exceptions are based on the idea that the circumstances surrounding the statement make it more likely that it's reliable, even though it's hearsay. There are five main ones to remember for the MBE: present sense impressions, excited utterances, then existing mental, emotional, or physical condition, statements made for medical diagnosis or treatment, and recorded recollection. A present sense impression is a statement that describes or explains an event or condition, and it's made while the declarant is perceiving the event or immediately afterward. So it's like a real-time account of what's happening. An excited utterance is similar, but it's a statement relating to a startling event or condition, and it's made while the declarant is still under the stress of excitement caused by that event. So it's like an outburst or an exclamation. Statements for the purpose of medical diagnosis or treatment are statements that describe the declarant's medical history, symptoms, or the cause of their injury or illness. They're admissible if they were made for the purpose of getting medical treatment or diagnosis. Then existing mental, emotional, or physical condition is a catch-all category for statements that describe the declarant's internal state at the time the statement was made. So it could be a statement about their emotions, their intentions, their physical sensations, or even their plans for the future. And finally, recorded recollection is a written record of something that the witness once knew but now can't recall. It's admissible if the witness made or adopted the record when the matter was fresh in their memory, and if the record accurately reflects their knowledge at the time.
Okay, that's a lot to take in. Present sense impression, excited utterance statements for medical purposes, then existing mental, emotional, or physical condition, and recorded recollection. 5 important exceptions to keep in mind, and last but not least, let's cover the hearsay exceptions that apply to records. What are the key ones for the MBE?
The three main ones are records of regularly conducted activity, or business records, public records, and judgments of previous convictions. Business records are records that are created and kept in the ordinary course of business. They're admissible if they were made at or near the time of the event and they were described by someone with knowledge of the event. Public records are records created by government agencies. There are three types of public records that are admissible under this exception: records describing the activities of the agency, matters observed pursuant to a legal duty, and factual findings resulting from an investigation, litigation. But there's a special rule for police reports in criminal cases. They're not admissible against the defendant under this exception. And finally, judgments of previous convictions are admissible to prove any fact that was essential to the judgment. So, for example, if someone was convicted of driving under the influence, that conviction could be used in a later civil case to prove that they were drunk at the time of the accident.
Okay, so business records, public records, and judgments of conviction. Those are the big 3 for record-based hearsay exceptions. Jackson, this has been so incredibly helpful. Thank you so much for walking us through all of this MBE evidence material.
My pleasure. I hope it's helped.
It definitely has. And for our listeners out there, as you continue studying for the MBE, remember to practice applying these concepts to actual questions. That's the best way to really understand how they work in different fact patterns.
Absolutely. And don't be afraid to dig a little deeper into the why behind the rules. Understanding the policy rationales can help you to remember the rules and to apply them more effectively.
That's a great point. Good luck with your studies, everyone.
You